Alec Baldwin beats the rap in the ongoing Rust shooting as prosecutors drop the gun enhancement charge due to a minor oversight by the prosecutors. Let's discuss. Hello, everyone, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. Today, we are talking about the Rust shooting. Alec Baldwin did a murder. He shot some people, but he was charged under the wrong law. That would be the minor oversight that I alluded to in the cold open. Let's discuss further. Prosecutors have downgraded the involuntary manslaughter charge, which isn't strictly speaking correct. They haven't downgraded it. It's still involuntary manslaughter. It's just they charged him under the wrong version. So they had to charge him under the correct version of the law. Mr. Baldwin's lawyers had argued this month that the district attorney had incorrectly charged the actor under a version of the law that was passed months after the fatal shooting. If convicted under that law, Mr. Baldwin would have received a minimum prison sentence of 5 years. That's 5 years on top. Instead, he faces a maximum of 18 months. Unsurprisingly, you can't change the parameters of a crime after the crime is committed. That's ex post facto. It's unconstitutional. When you commit a crime or don't based on the laws that exist at the time of the crime. That is the operative time. What law was changed afterwards doesn't really matter, neither here nor there, especially when it enhances the offense, because the state can technically make things less severe in a retroactive way because there's no prejudice to the defendant because it's less severe. But you can't make it more severe because that would prejudice the defendant, and that's unconstitutional. It would probably help if you charged him under the correct law. Yeah. In a statement, a spokeswoman for the district attorney said the prosecutor had dropped the firearm enhancement to avoid further litigation distractions. More to the point, you were getting your ass handed to you because you were charging him under a law that didn't exist at the time. So the litigation's distractions mostly being, we did it unconstitutional. That would be the nature of the litigation distraction. Lawyers for both Baldwin and Gutierrez-Reed had argued by charging their clients under the firearm enhancement law, prosecutors appear to be applying a version of law that had not been passed until after the crime occurred, which is a no-no. You can't do that. The version that was on the New Mexico books when Miss Hutchins was killed says the firearm enhancement applies when a weapon is brandished, not merely used. This is the distinction. In the new law, if a firearm is used in the commission of the crime, fine. But in the law that existed at the time that Baldwin committed the crime, which is what matters, it has to be brandished. According to the law's definition of brandished, which, by the way, is pretty much the same everywhere, give or take, was not some sort of novel definition. The action must be done with intent to intimidate or injure. Brandishing is not merely displaying a firearm. It is displaying a firearm with intent. That is brandishing. It is using a firearm to intimidate. It is using a threaten. This is the distinction, for example, between open carry and brandishing. Open carry is not necessarily brandishing for exactly this reason. Brandishing, as is defined, basically everywhere, requires some sort of intent to display the firearm, usually for some threatening purpose. And that wasn't how he was being charged. It doesn't make any sense to talk about brandishing in this particular context. Mr. Baldwin's lawyers had argued in court papers that prosecutors had not accused the actor of behaving in an intentional way that would be for the nature of brandishing, but rather negligently. If he had used the firearm in an intentional way to threaten, and then someone died, that would have been manslaughter with the firearms enhancement under the version of the law that then existed. If this movie had been shot a year later, then he'd be under a different law, but he wasn't. He's under this law that requires brandishing, which requires intent. But the prosecutor's entire theory of the case is negligence or recklessness. Either way, not intent. So, minor oopsies by the prosecutor charging under the wrong law and then arguing a legal theory that completely undermines a version of the law that does exist because they're charging him with something that doesn't work under the operative law. Gutierrez Reed wrote in court the firearms enhancement couldn't apply to her because she was not holding the gun. Gutierrez Reed was not brandishing. And she's not in a conspiracy to brandish. She's not an accessory to brandishing because she wouldn't have the intent to be part of that offense. The prosecutor's decision to drop the firearm enhancement reflects good ethical standard and was correct on the law. Their charge was unconstitutional. That was the problem, the Constitution, the ex post facto thing. You charged them under a law that didn't exist at the time. You can't do that. Baldwin's legal team has also made other challenges to the case, as you would expect. They've questioned the constitutionality of the district appointment of a special prosecutor, which, okay, I don't have any particular position on that issue, but fine. We can challenge that issue as well. And of course, there's not yet been a probable cause hearing, and the first such hearing is scheduled for this Friday. Thus, that brings us to the end of this story about the Rust prosecutors downgrading Alec Baldwin because they charged him under the wrong version of the law. And they said he was negligent and reckless, that he recklessly disregarded and was negligent and careless in his manslaughter. Careless, reckless is not intentionality. Brandishing, as defined in New Mexico, and for that matter, most jurisdictions, requires intentionality. Intentionality either to threaten, intentionality to coerce, intentionality to subjugate someone under the threat of the firearm. It is the latent threat that is the nature of brandishing. This is not brandishing under New Mexico or most state laws. So now Alec Baldwin only faces a maximum of 18 months, which realistically means he will never face a day in prison. As a first-time offender for an 18-month felony, no. His odds of going to jail for any length of time have basically dropped to effectively zero. He may well be convicted of the felony, which may screw him up in other ways, because being a convicted felon may inhibit his ability to travel overseas to other countries, which might inhibit his abilities as an actor. It would also prevent him from being in possession of firearms in the future because he'd be a convicted felon. So it might hurt him in that respect, but it's not going to hurt him as much as it did. A big win for the Baldwin defense team, who actually was quite correct on this score. Baldwin didn't do the crime he was accused of because the crime he was accused of didn't exist at the time of the offense. Minor details. And that, for the moment, brings us to the end of discussion of this story.